Welcome to the Global Justice Report, an online production of the Center for Global Justice. I'm Cliff Durand, your host for today. The Center for Global Justice, El Centro para la Justicia Global, is a multinational de Allende, Mexico. The center is devoted to research and learning for a better world and empowering a solidarity economy. Due to the pandemic, we have discontinued our in-person events and instituted online webinars. Without our previous revenue-generating programs, we now depend on your donations to support these webinars and to be able to continue to pay our Mexican staff. You can donate at our website, globaljusticecenter.org. Over the last 4 years, there's been a growing concern about the unrestrained power of President Trump. That was a factor in the voting of 81 million people against him last November. He was able to make frequently impulsive decisions with no one in the White House or even Congress or the courts able to hold him to account. The fear was that he was becoming a monarch who believed he was entitled to continue to rule even beyond his 4-year term. As threatening as this was to democracy, it was a bizarre extension of a tendency in the US presidency that has been building for over 70 years. The Cold War fostered a political context where increasing authority was given to the president. This was particularly so in the area of foreign affairs, leading some to worry about an imperial presidency. But it also frequently applied to domestic matters. When there is a feeling of insecurity, many seek comfort in authoritarian leaders. With the opening of the 21st century, fear of communism was replaced with fear of terrorism. With that, the Bush administration ushered in a major expansion of presidential powers that the other branches of government were unable to effectively check. The theory of the unitary executive played a role in this. It was chronicled, for example, in this book by Charlie Savage, Boston Globe reporter, Takeover, the Return of the Imperial Presidency and the Subversion of American Democracy, a tale in which President Bush played the role of the emperor and Dick Cheney was Darth Vader. Well, we are fortunate to have the Center for Constitutional Rights as an organization that has been in the forefront of defending human rights in the face of government overreach that undermine constitutional protections. And we're delighted to have with us today two attorneys from the Center for Constitutional Rights, Vince Warren, Executive Director, and Omar Farah, Senior Staff Attorney. They deal with such areas as abusive immigration practices, discriminatory policing, government surveillance, and extraterritorial imprisonment at Guantanamo. Well, they will be talking today about the expansion of presidential power and specifically the theory of unitary executive and its various manifestations that the Center for Constitutional Rights has been combating. Vince Warren will go first, Omar Farah will follow, and then there'll be dialogue following that where you all can ask questions or make comments. So let me hand the mic over to Vince Warren.
Thank you so much, Cliff. It's wonderful to be with everybody. Wishing you health and happiness, all of you, and warm buenos dias from the Center for Constitutional Rights. Cliff, I was also very happy to hear the reference to the Emperor and Darth Vader in your introduction. I am a tremendous Star Wars fan, and I figured that there's most of the things that we can learn about how we can move social justice really does come from the way of the Jedi. So I also say, may the Force be with all of you and all of us.
Yes, that film was quite prophetic.
It really was. So Omar and I are very, very happy to be with you all and to speak with you today about the imperial presidency. And, you know, Donald Trump is the worst place to start, but I'm going to start with Donald Trump anyway, with one observation from the many, many observations about that particular regime. But the observation that I want to focus on is this moment in 2017, which was in the first year of, and I also recognize that in addition to COVID time that we're all living under, there was also Trump time where things happened so quickly that it felt like things happened 10 years ago, but it all happened in the span of 4 years. And in the first year, I want to remind us of that moment when Donald Trump essentially fired the FBI director, James Comey. And what occurred to me at the time, as someone who was a student of politics, someone who is very keen on not taking the narratives from neoliberal administrations and trying to sort of move in their direction to try to think that it's progressive. I understand what neoliberalism looks like, but there was something that was particularly telling, which was I was talking to a colleague and said, why on earth, if a president was trying to take over and to essentially create a dictatorship, would he destabilize the domestic and even the international intelligence forces in doing so? History tells us that you can't take over these governments without the military, and you can't neutralize progressive movements and things like that without spying, surveillance, illegal detention, arrests, and so forth. We've learned this lesson in the United States, certainly, but it was very curious to me. And that's when I really got the first sense that this was not your average everyday dictator, that this was someone that was so steeped in narcissism that even the mechanisms by which the presidents could use to be able to move forward the unitary executive, this president was more concerned with loyalty of the particular actors. And so I'm going to come back to Trump a little bit later, but that's a fairly peculiar situation. And when we look at how we began, and I think where Omar and I are going to be talking about is not the 70 years of building of this, but we're going to be looking at it over the last 20 years. In September, it will be 20 years since 9/11. And 9/11, as we all know, was a catalytic moment in terms of presidential power, in terms of presidential action, unilateral presidential action, and also in terms of the cowing and the dismemberment and the dissolution of some of the checks and balances that are part of a democratic process to be able to keep the presidency in check. And the Center for Constitutional Rights has been involved very deeply, at least for the last 20 years, but certainly before that, in this particular question. And just to remind people that after 9/11, about 6 months after 9/11, in February of 2002, George Bush brought the first 20 men, took the first 20 men and put them on the prison island of Guantanamo and declared that these men were terrorists, but we didn't need to have any proof of that. He declared that they were the worst of the worst. He declared that they would all be put in detention for essentially until the quote unquote war on terror was over. And we know that the war on terror was essentially a state construct, and it would never be over until the construct ended. But essentially, it was indefinite detention. They wouldn't be able to have lawyers. They wouldn't be able to see the Red Cross. Nobody would be able to visit them. And most importantly, they would never, ever go before a judge or a tribunal to determine whether they were held lawfully or not. And in the space, in the panic, in the fear, as you were mentioning, Cliff, of 9/11, it was extraordinary for us all to watch how the mechanisms and structures that had been put in place to keep the president from doing things like that totally crumbled. Not only did they crumble and become useless to us, but also the people that were looking to revive them, that were looking to use these structures, things like congressional oversight, things like making sure that the president and the administration complied with the rule of law, both domestically and in terms of international rules and norms, that the people that were invoking those systems that had crumbled were essentially criminalized as well. And all of us at that time felt that this was essentially, this could sound the death knell for what we thought of as rule of law and democratic principles in the United States, if no one either would or could stand up to that President George Bush and to declare that what he was doing was illegal, unlawful, and needed to be stopped. And I'm very happy to say that Michael Ratner, who was the president of the Center for Constitutional Rights for many, many years, who died in 2016, was one of the lead lawyers that essentially created the paradigm of litigating on behalf of the men that were in Guantanamo, that were put in Guantanamo, litigating for the purposes of pushing back on this illegal and broad abuse of presidential power. And not only was it that, it was also arguably the largest human rights crisis in the United States in 50 years, or at least certainly since the internment of the Japanese during and after World War II, Japanese Americans. So I'm taking you back to that moment just to let you know that the Center for Constitutional Rights has been deeply involved in this work ever since that moment. And we have been watching and litigating and advocating against the serial the serial abuse of the human rights norms that keep us all safe and that keep the government as a servant of the people, as opposed to having people being the servant of the government. And Omar will talk more about Guantanamo, but I will say this: in those days, there was nothing that was a given. So we are lawyers at the Center for Constitutional Rights. Omar and I are lawyers, and lawyers are nothing essentially without clients. And so you might ask yourself, well, who were our clients at Guantanamo? Well, our clients at Guantanamo, when we started out, the people that were in Guantanamo, we didn't know who their names were, what their names were. We didn't know who was there, because the names themselves, the actual bodies of the people that were on Guantanamo, was considered classified information. Now, I want to ask you all to think about this question. There have been points in American and certainly in world history, but when has it been that a human being has been declared as classified information, such that no one was allowed to know where they were, who they were, what they were doing, and no one was able to have access to them? And this is how that whole process started. So it wasn't as if people were being taken from the United States that had families and friends that were missing. They were not being disappeared from the United States largely, so that family members, friends, and community can say, this person has been disappeared. Where is this person? Which allows lawyers and journalists and activists to make demands of the government for specific people that we know have been disappeared. This started in a very different way. These were people that were disappeared from countries around the world. And so what the Center for Constitutional Rights had to do was, we had to, in order to figure out who was at Guantanamo, we had to partner with human rights organizations, grassroots organizations from around the world, from virtually every country in the Middle East, from various African countries, where this information was pulled together about who had been disappeared, sent into the prison camps that were set up in Afghanistan, and who was then transferred to the United States. So this was done piecemeal by the NGO legal and advocacy community. We ended up having a sense of who the people were, and we started to make demands. But of course, the names were classified. We went to the Supreme Court 3 times, and in 2 of the Supreme Court cases, the court found that the right to habeas corpus, this is the right to go before a neutral tribunal or a judge to determine the legality of your detention, was something that applied to the men in Guantanamo. But I want to point out that that was a pitched battle that took many, many years to be able to do. And so if there's an example of how the unitary executive works, it is the idea that the government can, one, declare war and claim war on its own without congressional oversight, authority, or even opinion. 2, to take essentially hostages from those military incursions and to detain them in situ where they are. Also then to move them to an offshore military base in the United States outside of the prying eyes of lawyers and the human rights community. 3, to be able to essentially torture them in order to get information to bring more people into that legal black hole. 4, to destabilize the rule of law that gave rights to the people that are in that situation, to say that those rights do not apply to the people that the government says that they don't to. That constellation of activity that happened in the first 3 to 5 years of Guantanamo, as the world was watching, really formulates, I think, in the modern era, what the idea of the unitary executive looks like. So the question then is, if that's what it looks like, how do we begin as people, as regular people, to be able to fight that? One of the Center for Constitutional Rights founders, Arthur Kernoy, who was a law professor, a radical lawyer, and a law professor at Rutgers Law School, where I happened to go, and happened to be my constitutional law professor, very fortunately for me, said that most people think that there are 3 branches to American government. There's the executive, there's the legislative, and there's the judiciary. But in fact, there are 4 branches to American government, and the 4th branch is the most powerful, and that is the people. And in contrast to what we are seeing now in terms of how, quote unquote, the people are trying to move policy, the Trump people are trying to move presidential policy, back in 2001, the people had no say whatsoever and no information, frankly, about what the government was doing. And the government used the 9/11 attacks and used the threat of terrorism, this ever expanding threat of terrorism, both globally and domestically, as a way to silence protest, to even silence the ability of journalists and advocates to get questions answered about what was happening. So we were essentially living in 5 years of getting zero information except from 2 sources. Source number 1 was from the journalists that were able to get information about what was happening. Source number 2 was from the legal organizations like the Center for Constitutional Rights, who eventually found their way through a Supreme Court ruling to have access to the base and to start meeting with clients. And the information that you all learned about Guantanamo came essentially from those 2 sources. And we have to remember that this is how the idea of executive power, abuse of executive power works, is that they keep everyone in silence, they make everything classified, and then they will make it very difficult, if not impossible, for lawyers, for journalists to be able to get the information out that the government does not want out. So the reason why I'm telling that story, I wanted to ground us in those days of not knowing what was happening, and that every day over a course of 10 years was a new revelation about who was being tortured, about people sent to secret black sites in different parts of the world, which were also considered confidential, and people being tortured by U.S. entities, by U.S. contractors, by the military, by third countries and intelligence services, torture, a rampant global torture program. I wanted to take us back because it's as horrible as that stuff was. The source of why this happened was because it was essentially an experiment in democracy for us. And the test was for those of us who are on the left, for those of us who believe in freedom, for those of us who want to push back on the government excesses and don't believe everything that the government says is true. How do we take on a broad, very well-financed regime of work globally in order to be able to wrestle it down, bring these cases into court, and then bring the issues to the other two branches of government, the judiciary and the legislature, that could theoretically hold the government, the president accountable. So that's an important place for us to start. I would also say that very early on in this exercise, we at the Center for Constitutional Rights realized that, in fact, this was not limited to Guantanamo, and it wasn't limited to the quote unquote global war on terrorism, and it wasn't limited to what was happening in terms of foreign policy. That the next thing that was going to happen, which it did, was that all of the powers that the government illegally claimed that went relatively unchecked were going to be deployed internally in the United States against people who are immigrants, people who are Muslim, people who are Arab, people who are South Asian, people who are progressives and radicals. That this is how this power works. Once it manifests, it's like a one-way ratchet. And then if you've noticed that over the last 20 years, you cannot count the number of times that a presidential administration, a national security chief, a legislator or a judge has invoked the question of national security in order to stop you and I from doing the things that we should be doing, and in order to prevent the information that we need to be able to provide a check on the government from coming to us. The number of times that national security has been invoked over the last 20 years has increased exponentially, to the point where even the last president, number 45, was talking about that it was a matter of national security in terms of the way they dealt with the hurricane in Puerto Rico. This nonsensical idea that national security, if you just lay that card down, then everybody's like, well, the government gets to do what it's going to do. But we've seen it throughout, not just in the Bush administration, but we saw it in very pronounced ways in the Obama administration. 8 years of Obama, while he came in with great fanfare and he came in with great expectations in his oratory skills and hope for changing things, he did virtually nothing to change the way that the government approached questions of national security and terrorism. He had not closed Guantanamo, even though he said that he was going to. Once he put his mind to it, which, by the way, he put his mind to it more seriously in the second term than in the first term. The first term, he was looking at healthcare and pushed Guantanamo to the side. The second term, he looked at Guantanamo, was not able to close it. And I remember having a meeting with President Obama actually in 2009, right after he was elected, right after he was inaugurated. And I believe it was April or May of the year that he started. And in the meeting, he was saying to human rights advocates, listen, I want to close Guantanamo, but the problem that I have is Congress. They won't let me do it. And, there was that usual piece. And one of the things that we said, which did not go over very well in the Obama administration, I did not get invited back to any further meetings, was that we have clients that are in Guantanamo. They were in Guantanamo before you got here, and they cannot be in Guantanamo after you leave. That your legacy, as a human rights attorney, your legacy as someone that's going to right the ship in the United States is contingent upon your closing that military base, releasing the people that you have no intention of putting on trial, and putting on trial the people that you have no intention of releasing, plain and simple. And he bristled when I said that to him. And I'm not surprised that he did, because I think at the end of the day, he knew that in order for that paradigm to change, that he was going to have to give back presidential authority that was claimed and stolen by the Bush administration in order to move things forward in a way that is more equitable and more fair. And he frankly was not willing to do that. And as a result, what did we see domestically? We saw domestically a rise in immigration enforcement. More people were deported under Barack Obama than any other president in the US history. And the reason why that's important for this discussion, and why I'm making the point that this operated nationally as well as internationally, is because under the law, the president of the United States has what's called plenary authority to determine immigration policy. And plenary authority essentially means that the president gets to decide what the immigration policy is for the United States. And by taking a very harsh and punitive approach to immigration, and it sounded to many people, I don't think it fooled any people that were on this call, but it sounded to many people like it was a reasonable thing. Hey, what we're going to do is we're going to create a pathway to citizenship for these people. And for these people that are called criminal aliens, we're going to detain them and deport them. And of course, the issue is that the scope of the people that the administration determines are criminal aliens is an ever expanding category, and that families were torn apart even before Donald Trump around that particular question. But the idea is that to this day, the president still has plenary authority around questions of immigration. And an important political way to think about immigration is that immigration is actually not the issue that we have been grappling with, particularly with respect to Central and South America. We've been not really grappling with the question of immigration. Our problem is a foreign policy problem. It has to do with the massive amounts, millions of dollars that go to fund regimes that were seized by coup, like the ones in Honduras, that were looking to destabilize progressive regimes, the funding that was going to training paramilitaries and governments to repress progressives in Central and South America. All of that plays into what the government's priorities are. And so essentially, we find that our war making and our foreign policy drives the question of migration. And so if we're bombing in Iraq, and if we're bombing in Afghanistan, and we're bombing in Syria, that we are creating, the United States is creating a desperate migrant population that has to go someplace. If we are destabilizing progressive regimes in Central and South America, if we are funding the military, if we're supporting the military that does horrible, horrible things to the people that live in those countries, we are creating and generating a migrant population that is looking to leave. And so we find ourselves as part of the unitary executive, and as part of the framework that has been ushered in for many years, essentially creating the problem that we then create punitive measures to resolve. So we created in our illegal wars in the Middle East, we created a scenario in which we would have to come in and basically detain people. And we did this through essentially racial profiling in different parts of the world. For example, in Afghanistan, Afghanistans are not ethnically Arab or Muslims. So that if you have an Arab or a Muslim in Afghanistan, presumptively back in 2002, 2003, this person must be connected to terrorism. And they ended up in jails and prisons, and many of them often in Guantanamo, for no other reason other than that. With respect to Central and South America, that we're creating the conditions so that people come to the United States looking for a better life, only for us to then use our punitive reflex to repatriate them, detain them here, and to create a permanent underclass through executive action. So I wanted to sort of close up by talking about I also want to mention drones. That the drone policy is a key thing. So the Center for Constitutional Rights and the ACLU actually filed litigation challenging President Obama's use of drones, particularly with respect to the killing of American citizens. We represented the father of Anwar al-Awlaki. Anwar al-Awlaki falls into the category of a very, very controversial client. However, the principle that was at play there, which was that none of the rules of law that were applicable at the time or now allowed the United States to use drones and to bomb essentially countries with which we were not at war, unless there was an imminent threat to American lives. In the situation with Anwar al-Awlaki essentially had a big mouth. And he said, yes, death to the infidels. Yes, he said all sorts of things, but this wasn't the type of situation where he was looking to, for example, plant bombs in the United States. He was running his big mouth. And I think the US saw that as such a big threat that they used drone warfare under President Barack Obama to kill him, to take him out, and to take out his family members, and such and so forth. And so we had this policy in the United States where we stopped talking about the legality of using drones in the first place, but then we started talking about in policy spaces the idea of targeted killing. An FBI agent once said, in an article, he said that the answer of targeted killing is that if you're targeting one person with a drone and there are 50 people in the house, you've just killed 50 people. There's nothing targeted about that policy. And it also, even if there was something targeted about that policy, does not make it legal under international and constitutional law, particularly when it comes to killing American citizens. So I want to broaden up the scope to give Omar some space to talk about Guantanamo, and I'm hoping that he will touch on his work in Guantanamo. He started at the Center for Constitutional Rights as a Guantanamo lawyer, has had a number of clients who he has, through his legal efforts, gotten released back to their home countries. But he's also worked on other aspects of this unitary executive, even as it begins to apply to local governments. And one of the examples has been the spying program, which has been unleashed by the federal government, particularly with respect to Muslims, Arab South Asians in the United States, but it's been taken up and funded by local governments. And so one of the key cases that Omar has been instrumental in is a case called Hassan versus City of New York. I'm sorry, the City of New York, which is a lawsuit against the New York City Police Department for spying on Muslims. He's also been deeply involved in the spying infiltration of Black Lives Matter activists as well. Again, as the framework we were talking about is that we started off in 2001 thinking globally, knowing that all of these things were going to be manifesting internally. So I'll turn it over to my colleague Omar to tell you a little bit about some of the work that he's been doing.
Thanks so much, Vince and Cliff. Really grateful for the invitation. I'm kind of humbled because your brief introduction, I think, synthesized much of what we have to say over the course of this talk, which is essentially that crises, whether they're real crises or imagined, are the sort of predicate step in this trend towards expansive executive power that we've seen manifest itself in so many aspects of the Center for Constitutional Rights work, precisely because it I think dampens the reflex of the people to be suspicious of government power, and to put people in the shoes of government, and to be more comfortable surrendering some of the rights that they should have and the suspicion they should have of the way government wields power. I just want to reflect on a few of the more seminal moments of my work at the Center for Constitutional Rights, where I think my litigation and advocacy has come into direct conflict or direct tension with this notion. And one is in Guantanamo, as Vince mentioned. I won't try to retell the dark history of that prison, but it is worth just to paint the picture of how the way the abuses at Guantanamo that are, I think, an expression of executive overreach are operationalized in the way they play out in the lives of the people who have been detained there. I represented a man named Tariq Bauda. He was, before he was released in 2015, one of the longest serving hunger strikers at Guantanamo. From the very beginning of his time at Guantanamo, he recognized something that it took me quite a long time to recognize, which is that from where he stood, the president, the military, the courts, it was all part of the same expression of power that kept him locked up away from his family with no justification, and gave the power to those individuals who held the key to his door, and that the various modes of advocacy, both in court and out of court, that we talked about trying to engage at the time, he thought was simply an exercise in futility, because really it was really one person who had the power over his fate. And as a result, what he chose to do was to engage in a hunger strike in order to reflect back to the administration, the Obama administration at the time, the horror of what they were doing, the horror of putting someone in a cell in an offshore prison, not telling them when, if ever, they'll leave, and not even really telling them the full scope of the reasons why they were supposed to be there. Over his years on hunger strike, Mr. Bauda was force fed, as many men at Guantanamo have been over the years when they've engaged in hunger strikes. Over time, his physical health began to deteriorate severely until the point where he was an extremely precarious and dire situation. And at that point, in conversation with him, he became willing, in the true mode of CCR litigation, to use the prospect of litigation as a way of moving public opinion, as exposing some of the injustice that he was engaging in, not necessarily because he expected any relief from the courts. His case stood on a very basic principle, which is that if the government's claim is that he and the other men at Guantanamo are a threat, if it comes to pass that they are so sick or so old or so frail or so incapacitated for some reason that they couldn't possibly, then by the jailer's own logic, by the government's own logic, he shouldn't be continued to be detained. And that's something that's enshrined in the Geneva Conventions. It's been incorporated into American law. It's a very, I think, basic and logical proposition. And so we filed that case. But what we did, as we did that, was to approach the Obama administration at the same time, because of an artifact of legislation that barred the president from transferring men to the United States and put certain restrictions on his ability to release them to other countries without congressional approval. We asked them simply to not oppose that bit of litigation, because we're a federal court in the United States. To sign off on his case, to order his release, that would have freed the administration's hand and allowed them to release him. And I bring this up because, as Vince laid out in his introduction, one of the signature policy agendas of the Obama administration, at least stated objectives, was to close the prison in Guantanamo Bay. No more than several public addresses about that, in media statements, the executive order signed to much fanfare on day 2 of his administration. And so in some kind of peculiar way, it would seem, at least on the surface, that the interest of Mr. Bauda to be free, to be rushed to medical care where he could be rehabilitated from his years on hunger strike, and the administration's interest of reducing the prison population, ultimately closing it, would have been aligned, and that the government would have simply would have been able to stand down, not litigate, not contest a case that has no interest in winning, and allow Mr. Bauda to be raced to health and to freedom. But the administration, from public reporting, was racked by internal dissent and fighting, with the Department of Defense wanting to defend the principle that it can hold Mr. Bauda, the Department of State trying to negotiate his release. And ultimately, the Obama administration chose to fight that case, chose to litigate. And so its lawyers, the Department of Justice, stood up in court and made the case that Mr. Bauda's detention when he weighed all of 74 pounds after being on hunger strike for 9 years, being force-fed through the nose, was necessary and appropriate under the law. And the only way that absurd reality makes sense is if you understand that really what the government was doing in that case was fighting tooth and nail, litigating to the very end to defend the principle that the only way that Mr. Baoda, like the other men at Guantanamo, should leave that prison is at a time and a place and a manner of the executive's choosing. And that to me, I think, is just the clearest expression of the very absurd way that the embrace of expansive executive power twists even the government around its own interests. And so, when I think about how we have to combat this in our work, it's really important to recognize the deep investment within the executive branch, even with a supposedly more, at least superficially more restrained administration like the Obama administration, to say nothing of what we saw during the last four years. And as Vince said, it was quite predictable that this would start to bleed into areas of domestic law enforcement. Again, the crisis paradigm that Cliff started us out with is given license to all kinds of abuse, state and local as well. And so, in much the same way, one of the reactions to the post 9/11 fear that gripped the country was local police departments and the NYPD chief among them began targeting and monitoring in the course of their ordinary police work, shifting from a model of policing to punish unlawful conduct, to investigate crimes, to a model of trying to predict and anticipate and interrupt the next potential terrorist attack. And so the Center for Constitutional Rights, along with partners, litigated against the NYPD when revelations broke to the Associated Press that it had rolled out a massive post 9/11 surveillance apparatus that was organized around the idea of trying to watch, monitor, record, observe, and track really every aspect of Muslim American life in the tri-state area. The NYPD tried to have officers in every mosque within a 250-mile radius of the city. They infiltrated student affinity groups at local colleges. The reports revealed that NYPD officers even traveled on an excursion, a whitewater rafting trip with some students, and wrote down how many times they talked about religion and when they prayed and the like. And so our clients were a cross section of every American city that you could imagine: South Asians, Black American Muslims, students, private business owners, private homeowners. The only commonality they had was a stated profession and embrace of Islam, and that was enough to bring them totally within the sweep of the NYPD's program. And it's really powerful to see the way that case was resolved after litigation at the district court. We went to the Court of Appeals, and the order that came down rejecting the fundamental logic of the NYPD, which is that in order to protect against terrorism, you have to surveil the Muslim community because that's where the threat comes from, was exactly a hearkening back to some of the themes that Vince touched on and that Cliff that you touched on, that long history of expansive executive power around surveillance and targeting of disfavored or marginalized or presumptively threatening populations. The court likened it to the Japanese incarceration, to the Red Scare, to the kind of surveillance and infiltration that happened during the Civil Rights Movement. And then the last example, and this is one that I think seems disconnected from the post 9/11 paradigm, but is quite intimately involved with it, I think, is some of the work that I've done with Color of Change to uncover the ways in which the FBI and the DA and Department of Homeland Security, again, an entire agency that was developed by President Bush immediately after the 9/11 attacks to coordinate and to organize defense of the homeland, the way those agencies had been involved in the surveillance and targeting of Black political dissent, particularly the uprisings that emerged after the 2014 killing of Mike Brown and Eric Garner and so many other names tragically gunned down by law enforcement. And I guess I want to bring that up just to help shed light on how pervasive this kind of power is in American life. If you fall on the wrong side of the law, if you are Black or brown, if you belong to a Muslim community, if you are again presumptively threatening for some other reason having to do with your identity. The kind of records that we were able to uncover reveal a breadth of surveillance that is really kind of horrifying. And on the one hand, it's sort of absurd. We were able to get documents that reveal the FBI monitoring a social media accounts, one person who would happen to tag a post of hers with the hashtag BLM, and was also planning to attend a protest at a Walmart. I think it was in Maine or in Massachusetts, because the Walmart didn't have a gender-neutral bathroom policy. On Facebook, I think we were able to detect that only one person had really signed up to attend the protest, and yet this actually made its way into an FBI report, into the local field office, with the sort of proviso that comes with these things, to be aware that there may be some activity in this place. And so if you think about like what a micro level interaction that is, like a brief social media interaction with BLM, an interest to again, fully within the scope of her First Amendment rights, attend a protest at a local business, and that is being swept up and sort of picked up within the national apparatus of law enforcement. Again, more on the absurd side, but there are other documents that we uncovered that were really quite chilling. And one of them was a series of emails with an attachment, an entirely blacked out attachment, 7 pages long, that internal DHS correspondence was referring to as, quote unquote, the race paper. As in, here's the next draft of the race paper. We should meet to talk about these drivers and indicators of the race paper. The kind of document that we see at CCR, and I imagine folks on this call as well. There's just no good reason why the Department of Homeland Security is circulating a document that it's referring to as the race paper. And so we litigated to try to get access to that document. We weren't successful for reasons having to do with U.S. transparency statutes, but we were able to learn that the underlying analysis of that document was about developing an analytical framework to understand the growth of domestic race-based threats. And so this, for federal law enforcement agencies to be this actively involved in trying to understand and interfere and monitor and watch the very urgent, very, very desperately needed uprising of predominantly young Black people in this country for accountability around police violence and abolition and decarceration, to me is a signal of just of the creep of this kind of expansive view of executive power that it builds off of really where Cliff started us off, which is the use of threats, real or imagined threats, as a way of accruing more power to the executive branch and more compliance from people. And if there's any doubt about how braided these frameworks are, some of the other documents that we received were also, again, just kind of mind-boggling, including reports talking about the potential recruitment by ISIS of the protesters that we saw in 2014 and 2015 in Ferguson, who were talking about, again, accountability and justice for policing. In the logic of federal law enforcement organized around surveilling Black protests, like the step from young Black kids in the street demanding accountability in ISIS that's a half step, and I think, again, as sort of ridiculous as those things seem on paper, when you see the hyper-militarized reaction to First Amendment activity on the part of young people of color in this country, that starts to make sense. And so, I know one of the things we're wrestling with now is what is an appropriate reaction to the January 6th attack on the Capitol. And there's a groundswell of calls here in the United States for more legislation, stricter domestic counterterrorism law. And I think we need to be deeply suspicious of that kind of a trend, right? Because that sort of power, once it's in the hands of the executive, tends to get used in only one way. which is against the interests of progressives, against the interests of people of color, against the interests of other disfavored groups that are agitating for accountability and for a greater limit on executive power to give them the space to live their lives with freedom and dignity. So I'll stop there. I hope those three examples are sort of instructive, and they represent sort of how I look at this when I come up against it. And yeah, so I don't know, Vince, if there's something else you want to add on to that, or maybe you want to open up the floor to questions. I'm open.
Yeah, thank you so much, Omar. I just want to just be able to to tie us back together, and then I'll turn it back over to Cliff, if that's okay. Thanks for that, Omar. And I think you gave some really clear examples of how this phenomenon manifests. And I wanted to come back to the example of Trump for a moment, because at some level, he is that presidency and the current Biden administration is the recipient of all that we have ceded, all that we have let happen, all that we were not successful as a polity of fighting against and destabilizing. And so, but with the Trump administration, when you will also recall when he was naming his cabinet choices, that if you were like me, you were thinking, well, this is really interesting because Steve Bannon is more interested in decapitating liberalism than he is in the unitary executive. And that's what I thought. But when I began to see how things were manifesting, essentially the Trump administration had a different view of the unitary executive. And it wasn't that the power was invested in the presidency and should be invested in the presidency. It was that the power was invested in Donald Trump as a person who happened to be in the presidency. And that's the reason why that presidency sought to destabilize folks like the FBI in very strange ways. I have not been a fan of the FBI, nor has the Center for Constitutional Rights. We've litigated probably for 50 years against the FBI, but there were a couple of moments there where it was perplexing to figure out how to move when a presidential administration seemed to have no allies whatsoever, even in its own apparatus. Essentially, the idea that government institution had to go. And this creates, for, I think, the progressive, an interesting dilemma. And the dilemma is, does one preserve institution because that institution can be and should be the mechanism in a democratic society to push back on presidential power? So, for example, Trump was going against a lot of people. He was going against the media. He was going against the judges. He was going against activists. He was going against the Democrats. And while the preservation of the democratic talking points is probably not the most important thing for a group like the Center for Constitutional Rights to get behind, nonetheless, it represented a much broader piece, which is that if they can take apart the democratic institution, the democratic machine, they're going to obliterate the rest of us who are on the left of that. So at some level, we had to figure out where we were going to draw the line in solidarity with other folks. And same with judges. There's a lot of discussion now about whether, well, I'll put it this way, the revolution will not happen because of a court decision. That will not happen. We all know this to be true. However, we do know that particularly as the Center for Constitutional Rights practices the law, which is in support of social movements for social change, that the law can be used as a tool of oppression, but it can also be used as a tool of liberation if done the right way. So at some level, we couldn't give up on the attack on the courts that this administration was doing. Not that we agree with all of those judges, and certainly not because all of those judges agree with us, but because the institution that he was going after, if it were to collapse and to crumble, if the media were independent or corporate, ceased to be something that was taken seriously by the people, if the courts, conservative or Republican, federal or state, were something that an administration would never take seriously and wouldn't listen to, we've lost. And that was a very kind of interesting and key development, I think, manifestation, iteration of the unitary executive over the last 4 years. So I will leave it there and turn it over to you, Cliff.
Okay. Oh, fascinating discussions. I want to thank both of you for your insights and your rich experience. I'm sure that there are questions and comments that many of you will want to raise. And let me tell you how we're going to handle those. There are people watching this on YouTube. And if you are on YouTube and have a question or comment, you need to email them to us. And we can't see anything that you might put in the chat box. So send an email with your question or comment to global.justice.cliff@gmail.com. And I will monitor that and then pass the questions and comments on to our speakers. Those of you who are in the Zoom room with us will be able to ask your questions directly and engage in dialogue, perhaps. So if you are in the Zoom room, have a question or whatever, I will put everyone on screen view, gallery view rather, so I can see everyone. And if you want to speak, what you need to do is, number one, turn on your camera so I can see you, and then wave. And I'll call on you. Unmute yourself, and you can present your question or comment. Okay. Who wants to start us off? I know it takes a little time to get your thoughts together. Gregory just turned on his camera. Okay. Let me call on you.
I have not a very profound question, but a concerning question. The development of the unitary executive has been going on, I think as Cliff said in his intro, probably since World War II, post-World War II. And we saw the strange iterations of it, as Vince has just said, with Donald Trump's presidency. Nonetheless, whether it's Biden being president or whomever, that exists, and it's kind of a given by people in government. How does one check, so to speak? How does one use the power of the people, not only through Congress and electoral ways and perhaps judicial ways, to combat that? It's kind of like this tremendous edifice has been built, and we've all got to come up there with chisels and hammers and chip away at it. But I don't know if this is something you've been thinking of, a long-term strategy or anything of that nature to really cut it down to size, so to speak, where there's more of a balance. And I know it's particularly difficult in which you have a Congress in which part of it, the Senate, is completely, well, in my opinion, an undemocratic thing. So just as the beginning of a discussion, how does one go about cutting it down?
Thank you. Thanks for that, Gregory. I also saw that Cliff Shakira has a question. Do you want me to just do one question at a time, or?
Yeah, go ahead, please.
Well, I don't know. You said, Gregory, that it wasn't a profound question. It actually is, and it's also a difficult question. And you also tied one of the hands behind our back because you said, okay, don't talk about the elections, but talk about everything else. But I think there are two frameworks that are worth investing more deeply in. One is protest, and the other one is protection. And what I mean by that is that let's look at the current Black Lives Matter rebellions, uprising, George Floyd, going back even to before that to 2015 in Ferguson, where the Center for Constitutional Rights, we were supporting the activists and organizers that were protesting there. The reason why the protest piece is important is that other than voting, which is essentially making a demand through an electoral process that gets at some level diluted by a range of things, including the people that think differently from you, but I think also more importantly, the structural manifestations that keep voices from being heard. Voters from the South, for example, more Black people in the South than any other place virtually in America. And yet it's only recently that that power has been demanded. So there are challenges in the electoral process, structural challenges that we also need to be thinking about. But the protest piece is really important because it has been a long time since the demands of people in the streets made its way into a presidential electoral process. And so think what you might about Joe Biden. He is the first president to use the word white supremacy in a speech. And I'm not suggesting that that's the end of the road. I'm not even suggesting that that's the beginning of the road, but I'm suggesting that that is actually an indication that the powerful protests that folks have been, the demands that people have been making on the street, very righteous, moral, key political demands, are being heard and are resonating in our sort of national politics. And I think that's a very, very important piece. It's also important during this process of where the administration is naming its cabinet and various things like that, to be able to speak up pretty clearly on the histories of the people that are being nominated, particularly with respect to the unitary executive. So a lot of these folks came from the Obama administration, and a lot of these folks were really not friends of the progressive, at least with respect to these types of issues that we're talking about in the Obama administration. And this is an opportunity to at least to try to get people in here who would decode that a little bit, or at the very least to be able to mark this moment, to say that we are now going down the same road that we were going down from 2008 to 2016. That's also really key. And I think for the reasons that Omar laid out, particularly with Black identity extremism and what happens to people that are agitators, people that are protesters, people that are dissenters, particularly if they look like Omar and me, that it's important to be able to protect that space. And so I'm going to say something that I think is really important, which is it is great to protect protest, and we should do it all the time. It is particularly important, particularly necessary for people to be in solidarity and to protect Black protest and to protect protesters of color and Native protesters, because it's essentially the people with the least the people with the that at this moment have the least to lose in terms of the way that we're being treated, and not in the big democratic, our rights are being violated, but people cannot live their lives without being killed or by the police, taken down by an epidemic, and everybody wants to do studies about it. These are people whose lives are on the line, people who have been brought here, ancestors in chains, people whose ancestors lived on this land and it was stolen. These are the people that are going to be the leaders of naming the demands that will be transformative. It won't be the rest of us that have a ridiculously overbloated education and can talk about due process until the cows come home. It is actually the people that are the most affected. And so standing in solidarity in any way that's possible and protecting them as people, them as entities, them as organizations against the pushback that will come, and it will come from the Biden administration, although maybe with a velvet glove and not with a jackhammer like in previous administrations. That's some of the most important long-term work that we can do to be able to push back on the unitary executive.
We have a question that was emailed to us from Shakira. She's here in the Zoom room, but let me display the question that she sent. Can you speak to Associate Justice Robert Jackson's tripartite framework for assessing executive action in the context of this discussion. Is this framework an effective and enduring means of assessing the constitutionality of executive action? What is Congress's role in the evolution of presidential authority, both as an aggravating factor and a solution? For those who are not familiar with this tripartite framework, maybe you could start by explaining that.
Yeah, thank you.
Could I just add to
Please.
that, Mr. Warren and Mr. Farah, that since hearing your remarks, a new question has arisen, and I'm wondering if the framework is also a paradigm to begin with, if it's built on an acceptance of the evolution of executive power that is to begin with. So it's creating something that shouldn't be there. I'll leave my first two questions up for you to respond.
Thank you, Shakira. I was actually going to ask, it's been a while since I read it. I was wondering, I don't know if Omar has that at his fingertips, but it might be useful if Omar or you can very clearly sort of lay out what that is for the listeners. That would be very helpful.
I'm not coming, so I'm a lay person with no legal expertise.
I mean, I think part of what we've been talking about, the framework is just that when Congress has spoken quite clearly, the president is at its the presidency is at its weakest, where there is ambiguity, there's more parity, and then where something's been clearly delegated to the executive branch, then the presidency, the executive office has it's at its apex of its power. And I think part of the challenge that we've been trying to wrestle with here is the way that a lot of that has been kind of swallowed up by the power of the executive branch. And I think so much of the experience, certainly what we've been talking about with the post 9/11 framework, has been the either silent or express delegation of power to the executive branch under the logic really that it has to be the kind of fast-moving, nimble executive branch that can keep the public safe from the ever-present threat of the next terror attack. And I think what's so scary about that is one, it operates from a presumption that the normal checks and balances of our sort of democratic system are insufficient to the task of this particular threat of terrorism, which I don't think actually holds up. And then the second part of that problem is that there's really, and this gets to Gregory's question, there is really no system that we have that seems effective enough to unwind that power once it's delegated. It really is kind of a one-way ratchet, and it starts to bleed and creep throughout the system of government and certainly down to the state and local levels. And so, I don't know really what the solution is, other than things that we've been talking about. And I think it's kind of a term that gets kicked around a lot, the notion of intersectionality. But I do think for there to be kind of an adequate check on this, the people who find themselves at the tip of the spear of this expression of executive power have to start to recognize common cause, organize in ways that they haven't been so far, organizing around questions of economic justice, organizing around environmental justice questions that strike at all of us, although certainly Black people and people of color disproportionately, and start to build some accountability in that particular way. So it's a question you're asking about constitutional legal theory, but I think really it's playing out in our public lives right now.
Yeah, I would agree with that. And thanks very much for the question, Shakira. And also, you don't need to be a legal expert to know something that's messed up when you see it, or have questions about it, which I think you do. And I would add to Omar's point is, and this is part of the challenge, because there is constitutional theory that in a vacuum feels like it might work well. So we might all think of a scenario, in which we would want the executive to be able to act without having to go through Congress, without having to get the okay from the courts to be able to move something that's important forward. We also might recognize, a lot of us, that even if it would benefit us in the short term, that's a really dangerous situation in the long term. So if we think about the trend and how things have been moving forward, the other thing that's very important to realize is that a lot of the the unitary executive action essentially happens subjudicially, meaning that there is, for example, people that are going to be punished. If you're going to put people in a black site and torture them, if you're going to use drones to kill American citizens, if you're going to send folks to Guantanamo, if you're going to spy on them, there has not and there never will be a situation where the executive will ask permission to do that, because the answer is going to be no. And so that creates part of our challenge. And so, but it cuts both ways, because we were very critical of George Bush, the number of executive orders that he issued and the number of executive actions that he issued. Some people were not that critical when President Obama issued executive action around DACA recipients after we couldn't get things moving through Congress. And so a lot of the litigation that's been happening after Obama around immigration has been essentially the same type of theory that the Center for Constitutional Rights was litigating against Bush in previous years. And so that's part of the constitutional theory question. At the end of the day, though, the trend is that, to use to get back to Star Wars, Queen Padme Amidala, this was, I guess, after she was queen, said that, this is how democracy dies, to thunderous applause. And that's what ends up happening, that the trend is towards a dying democracy that is being spearheaded and pushed on by a cohort of very vociferous folks that are angry at whoever the threat target is. Whether, in the last couple of years, it was Mexicans. Before that, it was Muslims. Before that, it was political folks from Central America. Before that, it was Black folks. Before that, it was Japanese Americans. Before that, it was communists. Before that, it was Native Americans. There is a thunderous applause for undoing and continuing to subjugate these people almost by any means necessary. And I think, I haven't studied it, but I think that when you look at that trend over going past even before the World War II, that you will see a tremendous appetite to delegate power to the executive to do things like take land, kill people, deport folks, groups of people, because that's a way to be able to bypass some of the constitutional limitations on that, and not just in terms of what Congress and the courts need to do, but also in terms of the amendments to the Constitution, like the 14th Amendment to the Constitution, which doesn't allow the government to take that type of action against groups based upon race, national origin, or ethnicity.
On this question of how we can fight back, I want to try an idea out on you guys to see what you think of it. Unitary executive, of course, gives president great power, but it could also make him much more accountable for things that are done by the various agencies in the federal government. There's this film that has just come out, Judas and the Black Messiah, about the FBI and Chicago City Police assassination of Fred Hampton and Mark Clark. Now, that was clearly an illegal action. There seems to be very strong evidence that it was a federal agency that carried out an assassination. Well, why can't you then prosecute the president for murder? Or to take a more recent example, the drone uh, s- targeted strikes. Now, it is reported that President Obama individually signed off on those, that he wanted to be sure that there was good cause for it. But if it's illegal to assassinate a U.S. citizen, then why isn't it possible now to charge the former President Obama with murder? Is there any legal leverage that we could have in that way?
Yeah, so that's a great question. So I think, just trying that on for size, there are a couple of thoughts that we have an accountability problem in the United States when it comes to the executive branch, period, full stop. And we've seen that play out probably more viscerally than we might ever again in our lives over the past 4 years, and certainly over the past year, where we impeached a president twice. Going back a few more years, there was an investigation into wrongdoing, and there is a I wouldn't say it's necessarily a consensus, but there's certainly a sense that the president is not prosecutable for the acts that they take as president during the time that they are in the presidency, and it's not clear that they can even be prosecuted for that afterwards. So that's one of the impediments. The other broader impediment is the question of prosecution. Listen, Cliff, we can't get cops prosecuted for killing Black people on YouTube videos, right? And that, and we have these bizarre constructions, like there were a lot of people that were cheering for Robert Mueller when he was looking at Trump administration and campaign illegalities. But Robert Mueller was a defendant in the Center for Constitutional Rights lawsuit from when he was engaging in and giving the okays for the disappearing of Muslim and Arab men from the streets of New York right after 9/11. And so at some level, the prosecutorial class that we would rely on to prosecute people is aligned very deeply with the executive that is doing the bad stuff. So that's a challenge that we have in our democratic situation, is that people can call on anybody that they want to be prosecuted, but the political will to prosecute them is non-existent. And in fact, I can take you back to the days right after George Bush, and we were calling on all of us, and we in particular were calling on Barack Obama to start investigating, and if the investigation turned up information, to prosecute former Bush officials who had run, conceived, and implemented the torture program, which is clearly illegal under both the domestic and international law. And Barack Obama, as you may recall, said, "Hey, I'd rather look forward than look back." And I think that's the nub, that's the challenge. And so I think that it is actually harder to get prosecutors to prosecute the executive than it is to get the people to push the executive to start giving back some of their power. I wonder if Omar agrees with that. Oh, he's on mute. Anyway, that's
sorry there for that delay.
Yeah,
I think that's right. I mean, I guess I understand the spirit of accountability that drives your question, Cliff, and it is there's some internal logic to it. Obviously, the more power one branch of government accrues to itself, the greater prospect for accountability. Of course, the executive is exceptional in so many so many, actual and legal juridical ways that make that kind of accountability just impossible. And I think a lot of what Vince is saying and what the story of really the Center for Constitutional Rights is litigation in support of social movements, demands for justice is about, is that the courts are, they're just tricky places to go for your salvation. And so I think, as much as the executive branch, and this is what we've been talking about today, is sort of accrued more and more power to itself in greater areas of our political life, it's also true that the judicial branch isn't always a great check on that. I mean, some of the more extreme instances of executive overreach are beaten back by the courts and often to great fanfare. But I think a lot of times that tends to build much more confidence in courts to check the executive than we should have. And the Supreme Court takes a tiny fraction, minuscule fraction of the cases that come to it. Relatively few at the Court of Appeals. Most of what's happening at least at the federal level, is happening at the district court level. And there's been, a consistent, steady project on the part of the more conservative part of our political system here in the US to capture the courts over the last 20 to 25 years. And so, the courts in many ways are the biggest champion of this sort of expansive notion of executive power that we're wrestling with. So, it's complicated, and that's to say nothing of just like the technical immunities and power that the executive holds while he or she is in office. So it's a tough one.
Well, thanks for playing around with my legal strategy. But let me just add one other point in that regard. If it's a question of there being political will to prosecute, why didn't Trump prosecute Obama for those drone strikes? He wanted to lock Hillary up, but he could have even gone farther with Obama if he had wanted. But in any case, that's not a serious question, but just a little fantasy. Are there other questions or comments that anyone has been harboring? Let me check the email and oh, okay. All right, here's one from Roberto. Could you elaborate a little about the unchecked growth of presidential power related to Trump's despicable migration measures to contain the Mexican and Central Americans in the U.S. South border? Contain. How is it possible that Trump managed to force Mexico to hold asylum petitioners within Mexican boundaries? How could Trump split families, leaving unattended children in actual cages?
Thank you, Roberto. Yes, that's it's a really great question, and there are a lot of answers to it. So I think one of the things that I'll start off with is that so the Center for Constitutional Rights, we've had a number of cases in that area. We've had 2 cases, particularly with reunifying families where parents and children were in cages separately in different states. We've had a massive case in which we have been pushing for the use of asylum, allowing folks to claim asylum, which is their rights under international human rights, their rights under international human rights law and domestic law, and also to be able to have those hearings happen in the United States while they're in the United States. The administration, as you know, Roberto, has plenary authority to determine what to do, but that doesn't mean that the authority can be based on racial classifications, or that they can be in contravention of existing law. So even if we think about the Muslim ban, which is in a different context, which is essentially an immigration procedure, blocking people that were able to from coming into the United States based upon their religion, essentially, we challenged that as well, particularly with respect to folks coming from Yemen. And but the idea there is that the courts will allow the president to do those things unless we can show that it violates the United States Constitution or other existing law that Congress has put down. So with respect to asylum, this was a really key issue. And again, as I mentioned earlier, most domestic organizations think about immigration as a broad issue set. We, have our founding in the American South and built up a range of international human rights advocacy positions and cases. And so from that perch, we realized that the asylum question is probably, in addition to what's happening to people, is really one of the bigger, broader questions, that the United States presidency cannot unilaterally determine that asylum, political or other asylum, is just unavailable to people that come over, that try to come over the border. So that was an attack that we took. And the reason why the unitary executive plays into this is because it falls right into that niche where the courts recognize that the president has plenary authority around questions of immigration and actually has a great deal of latitude with respect to foreign policy, and that there are rights of the people that he is issuing dictates on that can check and pull into question whether the president can do anything that they want. And so that's the answer to it, is that when you combine a president that is wholeheartedly using the immigration question or the migrant question as a political wedge issue, and will go to his death saying that, horrible things about Mexican and untrue things about folks who are Mexican or Central American. You combine that with acolytes and sycophants within the administration, going back to remember when the people that he picked to be the Department of Homeland Security, which, by the way, took over the immigration pieces right after 9/11. That was another fusion of executive power, but that's a separate round of drinks. That there have been five Homeland Security chair people in the 4 years of Donald Trump's presidency, because what was happening is that in the face of trying to implement these horrible things, they were pushing back on him like, no, you can't do this. And he's like, guess what, you're fired, and I'm going to bring somebody else in who can. And that has been, and he finally at the end of he got, it was almost like the Saturday Night Massacre during Nixon. It's very much like that, where I just need somebody to find me a deputy attorney general who'll do this thing that I want to do. That's the practical answer about how it happened. Everybody that said, I don't think we should be doing this, he fired or didn't give the job to begin with. And the strategy in a 4-term presidency is do it and then worry about what the courts have to say later, because he's doing it for political reasons. He's not doing it for real policy reasons. And so he wins if he moves this stuff forward. We're in there going through the courts, and even though we're doing these emergency cases, that it's going to take 4, 6, 8 years for these cases to reach the court. Meanwhile, people have been in cages for 4 or 5 years. People are being pushed back from the U.S. border, being sent to home countries to determine their asylum application, which is crazy, being metered by Mexican officials because of the foreign policy power. I don't know this for a fact, but I think it has a lot to do with trade agreements. That if you do this, will be easy. We can talk about the trade agreements, right? So it's essentially incentivizing different countries to be able to support what is clearly not only an egregious and inhumane and horrible action, but it's also totally illegal. So the answer of how he did it was he built it, and then he let the rest of us sort of fight it out in court. Meanwhile, he got the political credit for it.
You want to say anything about the Federalist Society and its influence, thanks to McConnell, in reshaping the courts?
Yeah, those guys got to go. We're in a lot of trouble. The Federalist Society is an organization of conservative lawyers and jurists that are looking to stack the courts with judges that, charitably take an originalist view, that are more about preserving the law as it's been understood and the balance of power, and less about creating social justice opportunities. And they've been very organized for a very long period of time, even going back 30 years when I was in law school, and have changed the shape of the federal judiciary. I think Donald Trump might have appointed more federal judges than any president, in history, and certainly going back to the Kennedy era. And that has a profound landscape shifting effect on all of our work going forward over 30 or 40 years. As you know from the Supreme Court nominations, they're not necessarily spring chickens, but from a judicial perspective, they kind of are. These are young folks, a lot of them who are younger than I am, who will be on the court. It's a lifetime appointment. All federal judges are lifetime appointments for many, 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 many years, and they're going to be shaping the court for years to come. So for the cases that the Center for Constitutional Rights brings, particularly those ones that are trying to push the judiciary to be in support of social change as opposed to being the gatekeepers and pushing against social change, it'll be very hard and increasingly hard to convince them that the law, politics, and the facts as we present them should lead them to the conclusion that there should be less presidential power, that there should be more rulings that support the lived experiences of people that are being abused and oppressed, that there should be less rulings that are siding with corporate interests, that there should be fewer rulings that are pitting the penological interests of a prison against the lived experience of people in solitary confinement. All of these cases will be that much harder to be able to prove. And so if my thing is that the reason why we're at the Center for Constitutional Rights is because, just because the odds of winning are diminished because of more federal judges, that doesn't mean we are going to stop what we're going to be doing. I mean, to quote Han Solo, never tell me the odds, right? One of the things that we absolutely must do as a legal organization that is aligned with the left is to make the best, clearest, most powerful and aggressive arguments towards social change. And our job is to push the judiciary to a place where they can be open to the types of arguments that will keep our people safe, and that will be the kind of world that we want.
Well, we have run out of time, and I want to thank Omar and Vince for very stimulating discussions, and there are many thoughts I'm sure that we all will take away with us from this, and I hope that the members of our audience have enjoyed and benefited from this discussion. Let me remind you that it has been recorded and will be available on our YouTube channel, as are all of the previous webinars that we've had. You go to globaljusticecenter.org and you find we've got, I think, close to 40 webinars there now on a variety of topics, all very interesting. Next week, we will have a webinar on another fascinating topic: imperialism in the global South, Africa and Latin America. We have 3 speakers: David Barkin from Mexico, Patrick Bond from South Africa, and Ana Garcia from Brazil. And so covering 3 key countries in the global South. That's next Monday at 1 o'clock Central Time. I hope to see you back for that. And for now, then, this is Cliff Durand signing off. And I'm really happy to have met you both, Vince and Omar. I hope that maybe our paths will cross again in the future, and we certainly